Welcome to another episode of The Realty with ESG. I'm your host, Evan Saint-Gerard, and today we have a returning guest, Lou Delesio, who is a real estate attorney, one of the best here in New York, in Queens, Long Island. He pretty much works all over the place. And what are we talking about today?
We're going to do the process from offer to closing. I think I can, give you a good synopsis of what that entails and what the whole process is, because a lot of buyers and sellers don't understand how it all kind of works, and there's some outs in the contract and such that they should know about, and kind of when things kind of fall into place. So I think that might be the good thing to talk about today. And the inspection results come in. I typically kind of put that on the real estate agents to kind of negotiate if there's any issues that need to be resolved in that inspection report between the seller and the buyer. And I do that just because attorneys get in the way sometimes, and you guys have and you guys have a clearer line of communication between the buyer and the seller than we do, right? I can't talk to the other party, so I have to go through their attorney, who then has to go to them, then come back to me. It's like a game of telephone, so it's better to just kind of, if there are issues, for the realtors to kind of discuss it, get it squared away, tell the attorneys what was agreed upon, and then we'll put it into a repair addendum, or rider to the contract showing what has to be done prior to closing. Okay, so that's just with the inspection results. Now, the inspection results are done. We know what issues there were and what's going to be corrected. The next thing would be, the buyer, the realtor is going to send out a deal sheet, right, which is going to basically explain all of the terms of the transaction, the purchase price, the property, the down payment, the mortgage amount, whether there is actually financing or whether it's all cash, the buyer's information, the seller's information, if it's a co-op, the management company information, the shares, et cetera, okay? From there, the seller's attorney will, confirm that information with the seller to make sure it's all correct. The seller's attorney is going to prepare the contract. He's going to review the terms with the seller, and then he'll prepare the contract, send it out to the buyer's attorney, with the stipulation in the email or the letter that he sends or she sends, stating that their client has had a chance to review this contract in full, and it's subject to change, just so that the seller has the opportunity, or the other, to take a look at it and say, hey, wait, shouldn't apply, or whatever, right? And so the seller's attorney sends it out to the buyer's attorney. The buyer's attorney then will review the contract of sale that's presented by the seller's attorney, mark it up, which means that we're just gonna, if there's certain terms in there that we don't want, we'll cross them out, or we'll amend them to protect our client, the buyer, and then they'll send back that marked up. They'll review some of those changes with the buyers to make sure that they're on the same page, and then they'll send the markup to the seller, back to the seller's attorney, along with usually a purchaser's rider, that provides additional protection to the purchaser. Okay, at that point, the seller's attorney is going to review those proposed changes and markups, consult with the seller, and see if they're applicable, not applicable, risky or not risky, and whether they're, on a legal side, if they're acceptable, and if it causes a problem or could cause a potential problem if we allow them. Okay. After that, the seller's attorney will either send back an email or a phone call, go through the approved changes and say that what the changes weren't approved and why. A lot of times, most of the time, as the buyer's attorney, you're sending out a lot of the same markup, so why they don't want this or why they don't want that. But sometimes it just takes a phone call to kind of just say, hey, can you just explain to me why the seller didn't want to do this? And a lot of times they're very candid. They'll say, oh yeah, this isn't applicable, or the seller has to, the seller has to buy a place somewhere else, so they can't give you the extended time because they're locked in a place out of state or something like that, right? So you kind of find out what the lay of the land is, and the same thing on the purchases end. The seller attorney might say, well, why did you want it? And then you say, well, I needed this because my client is selling, so I wanted extra time on my end so that I can make sure that the deal is sold. I don't want to make the deal contingent because I know it's a seller's market or whatever it be, but I want to I need to have that extra time, and then hopefully you come to a meeting of the minds. once you come to a meeting of the minds, right, then you speak to the buyers, you make sure that the buyers are okay with it. And if they are, then you set up an appointment as the buyer's attorney to review the contract with the buyers, whether it be by Zoom, FaceTime, in person, telephone conference, whatever it may be. A lot of these deals now with COVID, it's a lot of telephone with DocuSign, FaceTime, Zoom. It's all that stuff now, as opposed to coming in, because people don't want to be at risk, right? So we would set that up. And the only thing on the buyer side is if you got to wire the down payment to the seller's attorney, or we got to provide a deposit check. So if we're doing a physical deposit check, I'll have the buyer's attorney, after the documents are signed, will send that check out to the seller's attorney with the contract stating that, here's the deposit and the partially signed contract of sale. Please send me a fully executed copy when signed by the seller. If it's going to be, a lot of times with DocuSign, a wire is easier because we're doing everything digitally. The buyers can go to the bank. We get the wire instructions from the seller's attorney, and the buyers will go to the bank and wire the funds directly to the seller's attorney.
All right, let's say we got the contract, it's reviewed. How long on average would you say should a buyer or seller expect for that time frame?
Okay, so I usually say from the day that a contract is from the day that the contract received by the buyer's attorney, I would say 5 days is probably the max that I would go on it, because you should be able to negotiate a contract in that period of time. Like if I usually try to, when I get a deal sheet on the seller side, I'm usually getting it out within 12 to 48 hours tops. So you give me a deal sheet, the contract's going to be out within that period of time. So, and 48 hours is a long time for myself, but say 24 hours, right? So that means it's going to the buyer's attorney, and then the buyer's attorney needs to review it. If they're a real estate focused attorney, they should return comments within another 24 hours. So you give yourself, 24 to 48, 24 to 48, that's 2 to 4 days. And then the last day to sign, right? And then you send it. So you should be in contract, I would think, within, 5 days, 7 tops, I would say.
All right. Speed is very important. So you have to understand, when you put an offer in and it gets accepted, if your attorney is not moving as quick as possible, then that could delay everything, and you could miss out. If you're a buyer or a seller, you could miss out. So it's very important that basically you have communication with your attorney, with your realtor. If things are not moving fast enough, you need to let everybody know so they know exactly who to speak to. They have to know the whole team. So you can't leave the realtor in the dark with not knowing who the attorney is, and vice versa. They have to communicate. So
no, the other thing I would say too is buyers and sellers need to understand that until both sides sign the contract and the money's deposited, that another offer can come in, or another buyer can come in and make a better offer, and the deal could fall apart, at any moment. That's why quickness, it's kind of strike while the iron's hot, especially in this market. So you want to get the contracts out, reviewed and signed as quickly as you can before, somebody comes in and swoops in and takes the deal from you. So just be careful.
There always is somebody or another deal that might be better than yours. So I just want people to understand that if you have a contract that's supposed to be going out, you need to talk to your attorney, make sure it's being sent out, it's being reviewed, and that attorney's responding and replying to the other attorney on the other side. That's very important also.
Whether you're selling or buying, if you're not an investor and you don't do this every day, this is probably one of the biggest things they're going to do in their life, right? So it's very important that they're involved in the process and they know what's going on at all times. So communication with the realtors is important, but communication with the client is very important as well. Okay, so everybody involved should know what's happening, and this way decisions can be made, because there are situations where another offer could come in, but being able to get into contract quickly is maybe more important than the extra $5,000 that the seller may get, right? So the attorney, it's important that the attorneys communicate and get things done in a timely manner. Getting back to the process, so now we wired the funds, we sent the contract over to the seller's attorney. Seller's attorney now has to meet with the seller and do the same thing. So they have to meet with the seller and sign the contract and deposit the down payment. Okay. Once the seller's attorney deposits the down payment and returns the fully executed contract back to the buyer's attorney, right, with the date on it, that's when all the time frames are going to start for the transaction. And the time frames that I'm talking about are going to be the on or about closing date, whether it's 60, 90, or a set date, that we put in the contract. And more importantly, the mortgage contingency portion of the contract, which is typically 30 or 45 days, mostly 45. Okay, so the clock starts ticking on those items when we get into contract. Okay, so the first step is the purchases. The first step after that is the purchase attorney. The buyer's attorney is going to disseminate and send out the contract of sale to the purchaser with a. I always put in there something about be mindful of the rate lock because it's a 30-day right of adjournment past the date of the contract. And they need to then forward that on and communicate that to the mortgage broker or the loan officer so that they now have the contract of sale so that the application can be completed for their loan. So that the 45, so that they can submit. Most of the times they have a pre-approval, but the pre-approval only covers a few things. I mean, they check your credit, they check your income and your assets, and they say, okay, we're willing to give you the loan. But there's more that goes into that mortgage contingency. Most importantly is the appraisal, right? So the bank has to, the quicker you get everything into the bank, the quicker they'll order that appraisal. And we don't want to be up against that 45 days. So we'd like to get it in 30. As quickly as you can get it, the better, because we get that contingency out of the way, okay? At the same time, the buyer's attorney is going to order a title search on the premises, on the buyers, on the sellers, on previous owners, right? To make sure that there's no outstanding judgments, liens, mortgages, estate issues, anything else that could possibly pop up that could give us a problem with closing. Okay, so that's happening at the same time that the buyer is attempting to obtain their loan commitment. The buyer's attorney is ordering a title to make sure the title is presented to the sellers and the seller's attorney to see what they have to clear. The typical time frame from the date that the contract is signed by both parties to closing is going to be 60 to 90 days. Okay. If it's a 60-day on or about date, it's going to be 60 to 90. If it's a 90-day on or about date, it's going to be 90 to 120. Just you add an extra 30 to whatever's on there if it's an on or about. So once the loan commitment's in, that's not the end of the buyer's responsibility under the contract. They have to get the loan lender has to clear their loan for closing. Okay. And what that typically is they want to get your homeowner's insurance. They want you to update your bank statements, your assets. They want to make sure that nothing's changed employment wise. Right. So once you get the commitment in that 45-day period, there could be another two weeks to a month before you're actually cleared and ready to close. And we can move actually towards getting the transaction to the closing table. Okay. Once we get the transaction to the closing table, we schedule the closing up. Usually with there's a TRID requirement, so the banks can't just put a closing on the next day. It usually takes at least 2 to 5 business days for them to actually get the closing on the schedule. They send their net funding sheet from the loan, because what happens is when the bank gives you the loan, they net out their fees. So if you're getting a $500,000 loan, at the end of the day, after they take out the taxes, that's the tax escrow, the homeowner's insurance escrow, the origination fees, everything else, you could be getting $495, right? So from that $500,000 loan, you're getting only $495. So they send that to the buyer's attorney. The buyer's attorney, computes his closing statement, communicates with the sellers to get the seller's attorney to get the check breakdown that they want for the sellers. We're paying off their mortgage, the remaining balance going to the sellers, and then we actually go to the closing. We still do physical closings in New York. We don't have to be there all the time, but most of the time it's an in-person closing, and we sign the paperwork for the bank. We sign, the paperwork for the title company. We get the deed in our name. Usually takes about an hour to 2 hours to get it done if there's no issues. And then, hopefully everybody walks out happy. The buyer walks out with keys. The seller walks out with their proceeds. And probably the biggest transaction of both of their lives are completed. And everybody walks away with a smile on their face. That's the goal.
Lou, thank you for your expertise, basically, and sharing your knowledge here. You've been watching The Real Tea with ESG and special guest Lou D'Alessio. Did I say it right this time?
Yeah, yeah, you got it.
I'll take that.
Thank you. Thanks for having me.
All right, anytime, anytime. So I hope you got entertained. I hope you got some education out of this video. Make sure you share this with anybody who might be